We will now get ready for the inaugural function. Now we will have Tamilthai Vaalthu by Dr. Jeeva Semmalar. Tamilthai Vaalthu.
நீராறுங் கடலொடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் வதனமென திகழ்பரத கண்டமிதில் தெக்கணமும் அதிர்ச்சிறந்த திராவிடனல் திருநாடும் தக்க சிறு பிறை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே சீரிழமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே வாழ்த்துதுமே.
IMA prayer by Dr. M. Inaugural, Chairman PPLSSS of IMA TNSB. Please keep standing.
May everybody be happy. May everybody be healthy. May everybody be free from pain. May everybody be free from sorrow. May be with a healing cure beyond every greed and lure.
Thank you. Thank you. Physician prayer by Dr. P. Lenin.
Physician prayer. Dear Lord, thou great physician, I kneel before thee, since every good and perfect gift come from thee, I pray. Give skills to my hands, clear vision to my mind, kindness and sympathy to my heart. Give me singleness of purpose, strength to lift at least a part of the burden of my suffering fellow men, and a true realization of the rare privilege that is mine. Take from my heart all guilt and worldliness, that with the simple faith of a child, I rely on thee. Thank you.
Thank you. Please be seated. I request the organizing committee chairman, Dr. K. Thangamuthu Ayya, to give the welcome address. வரவேற்பு உரை மருத்துவர் தங்கமுத்து ஐயா from பொள்ளாச்சி.
இந்திய மருத்துவ சங்கத்தின் தமிழ் மாநில கிளையின் PPLSஸின் வெள்ளி விழா மற்றும் மெடிக்கோலிகள் கான்க்ளேவ் 23 துவக்க விழாவில் கலந்து கொண்டு இங்கே வந்துள்ள அனைவருக்கும் என் வணக்கங்களை தெரிவித்துக் கொள்கிறேன். I have great pleasure of welcoming our chief guest, Honorable Justice Indu Malhotra, Judge, Supreme Court of India, who will be delivering a chief guest address this morning. மற்றும் இந்த கூட்டத்திலே பங்கு கொண்டு வந்துள்ள மெடிக்கோ லீகல் லிட்டிகேஷன் பற்றி தன் கருத்தை வெளியிட்டு இங்கே சீஃப் கெஸ்டாக அமர்ந்துள்ள சென்னை உயர்நீதிமன்றத்தின் நீதிபதி கணம் ஜஸ்டிஸ் சந்திர அவர்களையும் வருக வருக என வரவேற்கிறேன். தமிழகத்தின் அமைதி பூமியாக மாற்றிய ஆற்றல்மிகு தமிழக காவல்துறை டிஜிபி அவர்கள் காலையிலே உரையாற்றி சென்றார். அவருக்கும் என் நன்றியை தெரிவித்துக் கொள்கிறேன். தேசிய மருத்துவ கவுன்சில் தென் மாநிலத்தின் பிரதிநிதியாக பதவி வகிக்கும் மற்றும் தமிழ்நாடு மருத்துவ கவுன்சிலின் சார்பாக பல லட்சம் ரூபாய்களிலே ஒரு பெரிய மருத்துவ கவுன்சிலின் கட்டிடத்தை கட்டி முடித்து காட்டிய சாதனையாளர் டாக்டர் செந்தில் அவர்களையும் இங்கு மனமகிழ்ச்சியுடன் வரவேற்கிறேன். இந்திய மருத்துவ சங்கத்தின் தமிழ் மாநில கிளையின் தலைவரும் பிபிஎல்எஸ்ஸின் வெள்ளி விழா, மெடிக்கோ லீகல் கான்க்ளேவ் ஆகியவற்றை திறம்பட நடத்த வேண்டுமென ஆரம்பம் முதலே அவரது அயராது பணிபுரிந்த தலைவர் டாக்டர் செந்தமிழ் பாரி அவர்களையும் வருக வருக என வரவேற்கிறேன். இந்திய மருத்துவ சங்கத்தின் தமிழ் மாநில கிளையின் செயலாளர் என்ஆர்டி தியாகராஜன் அவர்களையும் முன்னாள் தலைவர் டாக்டர் பழனிசாமி அவர்களையும் தலைமை பதவி ஏற்குள்ள அபுல்காசன் அவர்களையும் 4 மண்டல துணைத் தலைவர் அவர்களையும் வருக என வரவேற்பதுடன் இந்த விழாவில் பங்கேற்றுள்ள அத்தனை விவிபிகளுக்கும் நல்ல முறையில் தங்கும் விடுதிகளை நமக்கு ஏற்படுத்தி கொடுத்த அசிஸ்டன்ட் செக்ரட்டரி விஜயசந்திரன் அவர்களையும் வரவேற்கிறேன். இந்திய மருத்துவ சங்கத்தின் பிபிஎல்எஸ் என்ற ஸ்கீமானது 1998ஆம் ஆண்டு ஏப்ரல் மாதம் 14ஆம் தேதி ஈரோட்டில் ஆர்.எம். கிருஷ்ணன் அவர்கள் தலைவராக இருந்தபோதுதான் அசீம் அவர்களாலும் தாம்பரம் டாக்டர் பாலசுப்ரமணியம் அவர்களாலும் டாக்டர் கேப்டன் ராகவல் அவர்களாலும் தங்கள் சொந்த பணத்தை முதலீடு செய்து இந்த பிபிஎல்எஸ் ஸ்கீமை தொடங்கி வைத்தார்கள். அப்படி தொடங்கி வைத்ததோடு மட்டுமல்லாமல் பிபிஎல்எஸ்ஸின் வளர்ச்சியிலும் அயராது பங்கெடுத்து கொண்டு தற்போது இந்த கான்க்ளேவில் கலந்து கொண்டுள்ள அண்ணன் பாலசுப்ரமணியம் அவர்களையும் கேப்டன் ராகவல் அவர்களையும் வரவேற்பதில் மிகவும் மகிழ்ச்சி அடைகிறேன். மெடிக்கோ லீகல் கான்க்ளேவ் 23இல் பங்கு கொண்டு உரையாற்ற வேண்டுமென கேட்டுக்கொண்டதை அடுத்து மகிழ்ச்சியுடன் இசைவளித்து அகமதாபாத்திலிருந்து இந்த கான்க்ளேவில் கலந்து கொண்டு உரையாற்றிய டாக்டர் ஜிஜேந்திர சர்மா அவர்களையும் உங்கள் சார்பாக ஐ வெல்கம் டாக்டர் ஜிஜேந்திர சர்மா ஃபார் கம்மிங் ஆல் ஓவர் ஃப்ரம் Ahmedabad to Chennai to patron in the Medico Legal Conclave 223 and our Silver Jubilee of PPLS. தமிழகத்தின் மகப்பேறு மருத்துவர்களின் வழிகாட்டியாகவும் கேன் துறையில் ஏற்படும் ஐயங்களை உடனுக்குடன் எல்லாம் தீர்த்து வைக்கும் ஆசானாகவும் திகழும் மெடிஸ்கேன் நிர்வாகி டாக்டர் சுரேஷ் அவர்களையும் மற்றும் அவரை இந்த கூட்டத்திலே பங்கு பெற அழைத்து வந்த முன்னாள் தலைவர் டாக்டர் ராமகிருஷ்ணன் அவர்களையும் அவருடைய மகள் டாக்டர் சுதா அவர்களையும் வருக வருக என வரவேற்கிறேன். இந்திய மருத்துவ சங்கத்தின் முன்னாள் தேசிய தலைவரும் தற்போதைய காமன்வெல்த் மெடிக்கல் அசோசியேஷனில் செக்ரட்டரி ஜெனரலாகவும் தன்னுடைய சிம்மக்குரலால் சீரிய கருத்துக்களை தமிழகத்துக்கு மட்டுமல்லாது அகில உலக அளவிலுமே பறைசாற்றி கொண்டிருக்கும் எனக்கு மிகவும் பிடித்த இந்திய மருத்துவ சங்கத்தின் இளம் தலைவர் டாக்டர் ஜெயலால் அவர்களையும் வருக வருக என நான் வரவேற்கிறேன். 2019 நடந்த மெடிக்கோ லீகல் கான்க்ளேவும் தற்போது நடந்து கொண்டிருக்கும் இந்த வெள்ளி விழா கான்வேலும் கலந்து கொண்டு நேற்று நடந்த மெடிக்கோ லீகல் ஒர்க் ஷாப்பிலும் சிறப்புரை ஆற்றிய முன்னாள் டிஎம்இ டாக்டர் எட்வின் ஜோ அவர்களையும் வருக வருக என வரவேற்கிறேன். இந்த மெடிக்கோ லீகல் கான்க்ளேவ் 2023 மிக சிறப்பாக நடத்தவும் இதற்கு முன்பு 2015 மற்றும் 19 நம்முடைய இந்த விழாவிலே பங்கு கொள்ள உச்சநீதிமன்ற தலைமை நீதிபதியாக இருந்த லகோத்தி அவர்களையும் தேசிய நுகர்வோர் பாதுகாப்பு கவுன்சிலின் தலைவர் அகர்வால் அவர்களையும் மேடைக்கு அழைத்து வந்து பேச வைத்து இந்திய மருத்துவ சங்கத்தின் பிபிஎல்எஸ்ஸின் பெருமையை உயர்த்திய காரணமான டாக்டர் நம்முடைய அன்பு நண்பர் திரு ஆனந்த் அட்வொகேட் அவர்களையும் அவர்களுடைய உதவியாளர்கள் செந்தில் அவர்களையும் அவருடைய உதவியாளரும் இங்கு வருக வருக என வரவேற்கிறேன். நேற்றைய தினம் நடந்த மெடிக்கோ லீகல் ஒர்க் ஷாப்பில் கலந்து கொண்டு மெடிக்கோ லீகல் ஆஸ்பெக்ட் ஆஃப் நியூரலாஜிக்கல் ப்ராப்ளம் என்ற தலைப்பில் உரையாற்றிய டாக்டர் பழனி அவர்களையும் பிபிஎல்எஸ்ஸின் சட்ட ஆலோசகராக ஆரம்பம் முதலேயே நம்முடன் பங்கு கொண்டு வரும் டாக்டர் சேரன் அவர்களையும் நான் வருக வருக என வரவேற்பதில் மிகவும் பெருமைப்படுகிறேன். அத்துடன் இந்த கூட்டத்திலே கலந்து கொண்டு 48/2008 என்ற சட்டத்துக்கு உயிரூட்டி அரசு ஆணையை முதலில் செயல்பட வைத்த நம்முடைய மருத்துவர் பேராசிரியர் கடலூர் சாமிநாதன் அவர்களையும் மிக சிறப்பான தலைப்புகளில் நம்மிடையே கலந்து கொண்டு நேற்று உரையாற்றிய வழக்கறிஞர் டி.கே. விஜயன் அவர்களையும், வழக்கறிஞர் மனோகரன் அவர்களையும், வழக்கறிஞர் ராஜேந்திரன் அவர்களையும், வழக்கறிஞர் பாண்டியன் அவர்களையும், வழக்கறிஞர் மிதுன் சக்கரவர்த்தி அவர்களையும், வழக்கறிஞர் பாண்டியன் அவர்களையும் வருக வருக என வரவேற்கிறேன். PPLSஸின் வெள்ளி விழா மற்றும் வெடிக்கோலிகள் கான்க்ளேவ் 23 ஆர்கனைசிங் செக்ரட்டரியாக செயல்படும் டாக்டர் சந்திரசேகரன் அவர்களையும், கடந்த 4 மாதங்களாக மெடிக்கோ லீகல் கான்க்ளேவை சிறப்பாக நடத்த வேண்டும் என ஆர்வத்துடன் செயல்பட்ட செக்ரட்டரி மற்றும் சிறப்பாக நடத்தி முடித்துள்ள நம்முடைய டாக்டர் மணிவண்ணன் அவர்களையும் வருக வருக என வரவேற்பதுடன், இதைவிட சிறப்பாக மெடிக்கோ லீகல் கான்க்ளேவை அடுத்த ஆண்டு நடத்தி காட்டுவோம் என உறுதி பூண்டு 5/4/2023 PPLSஸின் தலைவராக பதவியேற்றுள்ள டாக்டர் இளங்கோ அவர்களையும், செயலாளர் டாக்டர் லெனின் அவர்களையும், பொருளாளர் பால கணேஷ் அவர்களையும், லீகல் கமிட்டி சேர்மன் பொன்னுராஜ் அவர்களையும் வருக வருக என நான் வரவேற்பதில் மகிழ்ச்சி அடைகிறேன். PPLSஸின் வளர்ச்சிக்காக தொடர்ச்சியாக ஆலோசனை கூர்த்தி வரும் முன்னாள் தலைவர் டாக்டர் கணபதி அவர்களையும், முன்னாள் தேசிய தலைவர் அருள்ராஜ் அவர்களையும், விஜயகுமார் அவர்களையும் மற்றும் பிரகாஷ்மா அவர்களையும், குணசேகரன் அவர்களையும், டாக்டர் ராமகிருஷ்ணன், டாக்டர் ராஜா, டாக்டர் சுகுமார், டாக்டர் அன்புராஜன், டாக்டர் ரங்கநாதன், டாக்டர் பாலமுருகன், டாக்டர் கார்த்திக் பிரபு, டாக்டர் கருணா, டாக்டர் திரவிய மோகம் மற்றும் இங்கு கூடியுள்ள அனைத்து நிர்வாகிகளையும் மருத்துவ நண்பர்களையும் வரவேற்பதில் நான் மிகவும் மகிழ்ச்சி அடைகிறேன். PPLSஸின் சில்வர் ஜூப்ளி மற்றும் கான்க்ளேவுக்காக பல லட்சம் ரூபாய்களை எக்ஸிக்யூட் பேக் நன்கொடையாக அளித்து இங்கே இந்த கூட்டத்தில் கலந்து கொண்டுள்ள ஈரோட்டைச் சேர்ந்த டாக்டர் சுதா சரிக்கை கருத்தரப்பு மையத்தின் இயக்குனரும் என்னுடைய அன்பு சகோதரியுமான டாக்டர் தனபாக்கியம் அவர்களுக்கும், PPLSஸின் அனைத்து கான்க்ளேவுக்குமே முதல் நன்கொடையாக எப்போது காண வேண்டும் என்று கேட்டாலும் குறைந்தது 1 லட்சத்தையாவது ஒவ்வொரு முறையும் கொடுத்து கொண்டு வரும் கும்பகோணத்தைச் சேர்ந்த KG மருத்துவமனையின் நிர்வாகி டாக்டர் சாந்தி அவர்களையும், ஐஸ்வர்யா மருத்துவமனையின் மருத்துவர் டாக்டர் சந்திரலேகா அவர்களையும் இந்த கான்க்ளேவுக்காக கேட்டவுடன் முதலில் 50,000 ரூபாய்க்கான செக்கை கெடுத்த தஞ்சை மாநிலத்தின் மைந்தன் டாக்டர் சசிராஜன் அவர்களையும் வருக வருக என வரவேற்பதில் நான் மிகவும் பெருமையடைகிறேன். அதே நேரத்திலே இந்திய மருத்துவ சங்கத்தின் தமிழ் மாநில கிளையின் PPLSஸின் சார்பாக தற்போது நடந்து கொள்ளுந்த இந்த விழாவிலே பங்கு கொண்டு நம்முடைய உரையாற்றியுள்ள உச்சநீதிமன்றத்தின் நீதிபதி கணம் இந்து மல்கோத்ரா அவர்களுக்கு தமிழக மாநில கிளையின் சார்பாக அவருக்கு நாம் அனைவரும் பங்கு கொண்டு ஒரு ஸ்டாண்டிங் ஓவேஷன் கொடுக்க வேண்டுமென உங்களை எல்லாம் தாழ்மையுடன் கேட்டுக்கொள்கிறேன். அவங்க உட்கார சொல்லுங்க, மேடத்தை உட்கார சொல்லுங்க, மேடத்தை உட்கார சொல்லுங்க. Respected Madam, now all over India, many of our doctors are affected by CPA in one way or other. Since 1996, more than 50% of doctors for every year directly affected by CPA. Thousands of the cases are pending in the consumer forums. Doctors are not able to do their duty peacefully. Apart from more than 20 doctors are arrested under 304A and cases are pending against them. Realizing our difficulties, our Honorable Prime Minister Narendra Modi's government already passed an act in 2019 by deleting health care from CPA with the majority members of support of Rajya Sabha and Lok Sabha. Unfortunately, it was not accepted by Supreme Court of India by quoting the 1996 judgment of Santa versus IMA. I request Honorable Justice Indu Mathura help us to get away from CPA from doctors. I request you to kindly help us, madam. We are waiting for help. Thank you, Nandi.
Thank you, Dr. Tangamuthu sir, the doyen of PPLSS, the savior of so many doctors across Tamil Nadu. He has the record of clearing up almost 95% of the legal complaints that have come to him for replies. He gives so much wonderful replies, very assisting the councils, fighting, because most of the councils may not know the medical aspects. He had been guiding our councils at various districts with his replies, wonderful replies. Thank you, sir. We are honored by your presence here. Now I request our President, Dr. Sendamil Pari, sir, to give the presidential address.
Respected former Supreme Court Judge, Justice Honorable Mrs. Indu Malhotra, respected Honorable Justice Thiru Jagadish Chandra, Judge, Madras High Court, respected Dr. J.A. Jayalal, Secretary General, Commonwealth Medical Association, Dr. K. Sendil, Member, MAC, PG Board, National Medical Commission, Immediate Past President, Dr. Palanisamy, President-elect, Dr. Abul Hassan, Vice Presidents, Dr. Govindarajan, Dr. Aruna, Dr. P.T. Saravanan, Dr. Treviya Mohan, State Secretary Dr. Ennatya Tyagarajan, State Finance Secretary Dr. Alaga Venkatesan, Joint Secretary Dr. Vaibhav Suresh, State Assistant Secretaries Dr. Vijay Chandar and Aravali, past National Presidents, past and present office bearers of PPLSS, PPLSS advocates and delegates of this medico-legal conclave. It's my great privilege and honor to stand here on the podium as a state president of Indian Medical Association of Tamil Nadu State Branch at this historical moment of PPLSS Silver Jubilee celebration. PPLSS is one of the novel schemes of IMA which protected thousands of doctors from medico-legal litigations. This is possible only because of our legal team headed by Dr. K. Tangamuthu, our legal committee chairman, now legal committee advisor. Most of the cases were not pursued by litigants due to proper and effective reply by Dr. K. Tangamuthu. Due to this, we were able to procure surplus money from the scheme, and out of which we could purchase 2 guest houses worth of 100 crores and invested rest in the fixed deposits. At this juncture, I would like to express my profound thanks to the past PPLSS office bearers of the dedicated work to uplift the scheme. It's not out of place to remember here the assistance rendered by our PPLSS panel advocates, and without which it might not have made possible to win most of the cases in the court. I convey my gratitude and thanks to our advocates for their excellent services. It's our great privilege to acknowledge the gracious, simultaneous presence of our former Supreme Court Judge, High Court Judge, and the DGP of our state on this occasion. IMA would be very much thankful for the guest who delivered lectures and graced the occasion. My heartfelt thanks to all delegates of the conclave for the lively participation. Long live IMA. Jai Hind.
Thank you, sir, for your crisp presidential address, recognizing the services of former PPLSSS office bearers, but for whom will not be sitting here today, enjoying the Silver Jubilee celebrations. Now, I request State Secretary Dr. NRTR Tyagarajan to give the State Secretary address.
Good afternoon to all. Respected Justice Indu Malhotra ma'am, Justice Judges Chandra sir, President, Organizing Chairman, Secretary, galaxy of past presidents, PPLS district coordinators, and to my friends of all amazing participation from the entire crowd and amazing presentations over the past 2 days. It's been very useful, I think, to all of you who've attended from the start of yesterday to the end of today. And we've learned so much, and all this is being recorded and it will be shared with you from the state office to by YouTube, and it will be sent via all media to all your mails and all. And I'd like to thank you all for participating. I'd like to thank all our sponsors for getting this done. And PPLSS 25 years, it's a seed which 25 years, இப்போ ஒரு பெரிய மரம் ஆயிடுச்சு. அந்த சீட் வந்து அசீம் சார், ராகவேலு சார், TNR and TN Ravishankar sir and Bala sir, when they conceived this in 98, like they wouldn't have imagined it would have become so big today. And as the numbers, our president had quoted such huge numbers. But more than the numbers, so many lives of the doctors that it has changed. ஒரு 3000 பேர் 4000 பேர் அது you feel so safe, secure. PPLSS, there's someone to write your replies. Case sheet கொடுத்தனுச்ச போதும், you get your replies. Those of you who face that would have obviously அதோட அருமை வந்துட்டு அந்த each of those 3,000 or 4,000 replies that have been drafted by the Thangamuth sir. And first thing, Anand David sir, like he's the backbone of today's function and the PPLSS. Sir, thank you so much for organizing this. And this is a very special day for us. And 25 years, sir, that's a very long journey that we've had together. And thanks to all of you, and a salute to all of you who created this, all the fronts, and in various capacities from that seed. From that small seed in 95, it's a mega banyan, mega tree now 25 years down the lane. And hats off to all the office bearers who've contributed to, in various ways, to nurture what PPLSS is today, to the behemoth that it is today. And amazing participation again. Thanks to you all for participating. And ma'am and sir, thank you for coming all the way down and participating and looking forward to your speech so eagerly. So I don't want to take too much of your time, and thank you, ma'am. Thank you, sir.
That's the State Secretary, man of few words, but very effective ones, recognizing the services of those who started this scheme, and thanking Advocate Anand David for all the arrangements he has done on the legal side. Thank you, Mr. Secretary. Now, honoring the guests, I request the State President to honor Justice Madam Indu Malhotra. He will be adorning a shawl on her, and a memento will be given by the organizing committee chairman. Sir, Thangamuth sir, adu kodunga sir. And thank you so much, ma'am, for being with us on this day, traveling all the way down. We are waiting to listen to your wonderful speech. Now I request Honorary State Secretary Dr. NRTR Tyagarajan to honor Justice A.D. Jagdish Chandra sir. And She will be adorning the shawl as such, and the mementos will be given by the organizing committee. I take this opportunity to request the justices to honor our past PPLSS office bearers in the presence of our state office bearers. I request all the past PPLSS and state office bearers to be ready to receive the honors. Madam will address us first, and then I request Madam to light the Kutuvalakku.
Okay. Sure.
And then give the speech. Madam, I may request Kumudha Lingaraj, Madam, Dr. Shanta Narayanan, Madam, Dr. Karuna. Dr. Karuna, are you there? Please join them, please. Thank you so much. Retired Judge, Justice Indu Malhotra Madam is a former judge of the Supreme Court of India. She is now practicing as a full-time arbitrator in both international and domestic arbitrations. Prior to her elevation, she was practicing as a senior counsel in the Supreme Court of India and has appeared before various high courts. In 2007, she was designated as senior counsel by the Supreme Court. In 2018, she was the first woman to be directly elevated from the bar as a judge of the Supreme Court of India. Congratulations, Madam. Justice Indu Malhotra has specialized in the field of arbitration and has contributed significantly to arbitration jurisprudence, both as a counsel and as a judge, when she has authored significant judgments in arbitration while she was on the bench. She is a fellow of the Chartered Institute of Arbitrators, London, and is empaneled with the Mumbai Center for International Arbitration, Singapore International Arbitration Center, Indian Council of Arbitration, Delhi, International Arbitration Center, and the Associated Chambers of Commerce and Industry of India, ASSOCHAM. In 2005, she was nominated by the Chief Justice of India in the category of eminent persons as a member of General Council of the Gujarat National Law University. Justice Malhotra was also appointed as a member of a high-level committee in 2017, constituted by the Ministry of Law and Justice, Government of India, to review and make recommendations on the working of existing arbitration institutions in India and suggest legislative amendments to the Arbitration and Conciliation Act 1996. The 2019 amendments to the Indian Arbitration and Conciliation Act 1996 are mostly based on the report and recommendations of this committee. Justice Malhotra has published the 4th edition of the Commentary on the Law of Arbitration in India in March 2020, published by Wolters Kluwer. The commentary has been cited by the Supreme Court and High Courts in various judgments. We are very much honored to have such an illustrious person amidst us, Madam. Please give us your knowledge and share some of your knowledge with us. Over to you, ma'am. I request our President around the medallion on the speaker.
Honorable Justice Jagdish Chandra, Judge, Madras High Court, Dr. Sentha Mil Pari, President of the Indian Medical Association, Dr. N.R. Tyagarajan, Secretary IMA, Dr. Thangamuthu, Organizing Chairman, Dr. Chandrasekhar, Organizing Secretary, dignitaries on and off the dais, my warm greetings to all of you. I am humbled by the request of being invited to chair the inaugural function in the Silver Jubilee celebrations of the Tamil Nadu branch of the IMA. Medical negligence is a subject of great interest to me for the reason that while I was practicing as a senior lawyer, I did a large number of medical negligence cases, and these cases were in fact done on behalf of hospitals and eminent doctors. And that is how my familiarity with this subject comes. And while I was in office, I did have the occasion to decide some medical negligence cases, which I will also refer to in a little while. I think it is of utmost importance, and that is why I have specially come for this function. And I do attend a lot of functions of medical conclaves and seminars because I think it's imperative to have doctors completely aware of the legal position as it stands on date. The law of medical negligence has evolved through judicial decisions of the National Commission and this High Court, not High Court, Supreme Court, because the appeals come directly to Supreme Court. So I do intend to touch upon the landmark decisions which are in force today, and that is why I thought it would be probably more impactful to do it through a PowerPoint presentation. If you all have any questions, I'll be happy to answer them. So it's in 1995, medical services were brought within the purview of the Consumer Protection Act 1986 under deficiency of service. And ever since, it's a consumer fora which has been adjudicating disputes of medical negligence even to date, even though the act has now been repealed and the new act has been brought into force, which is in 2019 brought into force with effect from 2020, which has been brought into force on 28th of July 2020. The second act, the new act, was also challenged in the Bombay High Court by medicos, saying that they should not be covered by the Consumer Protection Act. However, based on the jurisprudence, when they were first included under the Consumer Protection Act of 1995, prevailed with the court, and they said that they would continue to remain covered by the Consumer Protection Act, even though I personally have serious reservations on this issue, which I will touch upon again at the end. And the specially petition against this judgment was dismissed. So today they are still covered under the Consumer Protection Act. In the first landmark decision of Supreme Court was in IMA versus VP Shanta. Just keep changing the slide. Change the slide. Otherwise, I'll do it. Huh? Yes. Yeah, it's fine. The Supreme Court observed that a professional man owes to his client a duty in tort as well as in contract to exercise reasonable care in giving advice or performing services. The standard of care is that of a reasonably competent medical practitioner in that field of specialization and not of the most skilled person in the field. You're not expected to be a brilliant doctor. You should be reasonably competent. You should be familiar with that branch of law. And a reasonable, competent medical practitioner is the standard which is expected when a case comes to the court. And the judgment in this is Kusum Sharma versus Batra Hospital, where Supreme Court had mentioned this. It's neither the very highest nor a very low degree of care and competence is required. If the medical practitioner follows a practice acceptable to the medical profession, even if a better alternative is available, it is not negligence. Now, what is actionable negligence? Actionable means that where can negligence give you a cause of action of suing a hospital or a doctor? Now, actionable negligence is neglect, exercising a reasonable degree of skill and care which has resulted in injury to the patient. The essential components of actionable negligence are legal duty to exercise care to the patient, which Justice Jayachandra had just mentioned a little while ago. Breach of that duty, for instance, failure to inform a patient of known risks which may occur. Damage, injury caused to the patient directly as a consequence of such breach or undisclosed risk. Injury must be sufficiently proximate to the breach of duty. If the injury is caused directly by the action, negligence of the doctor, then it is actionable. And the cause of action arises only when damage occurs, since damage is a necessary ingredient of the tort. Breach of that duty would give rise to an actionable claim of negligence. It's important, in fact, this was the last line which I want to read is from my judgment in the Supreme Court, wherein we said, if standard procedures and norms are not followed, it will amount to medical negligence. And I will give you the context, otherwise it won't make sense. This was a case in Maharaja Agrasen where a child was born prematurely and the doctors did not carry out the ROP test, which is retinopathy of prematurity. It is now mandatory under the regulations and AIMS has also notified it. Apparently, the gynecologist was not aware, she didn't put the child on to the ophthalmologist and the test was not carried out. And it was only when the child turned 6 months that the mother realized there was something wrong, why the child was not responding and there was, no expression in the child's eyes. And then she started asking for the medical records. The hospital refused to give the medical records. And by then 2 years had passed and she eventually discovered that the child had turned completely blind. It was at stage 5, which is irreversible. So that was a case which went to the National Consumer Disputes Redressal Commission and they had granted compensation, which I affirmed while I was in the Supreme Court, and we did award compensation against the doctors as well as the hospital. So this is a case where you have not followed the standard practices and procedures at all. So awareness of what are the current standards, every doctor should familiarize himself with that specific branch of law. Now there is no liability when a doctor, where there's an error of judgment or you choose a reasonable course of treatment, there's no liability, there's no negligence. A mischance, accident is a human error. It won't amount to negligence. There are inherent complications, known side effects, which happen prior to a treatment which is administered. Law recognizes dangers inherent in surgeries. Mistakes may occur. Despite exercise of reasonable skill and care, that would not be negligence. In emergent circumstances, there is greater allowance made for mistakes taking into account the risk-benefit test. There was a case which had come, which I had appeared in for a leading cardiologist in India, where a doctor who was a patient had a problem. He had in the aorta, he had an aneurysm, and it was in a position where it was about to burst. There was no time. He obtained, the doctor who was a patient was not in a position to give his consent. He realized that if he was not treated, he was not going to survive. He undertook the surgery, the doctor survived, and he recovered. 2 years later, he filed a medical negligence case against the cardiologist. And thereafter what happened is that the doctor who had done the surgery was deeply hurt because he felt he had done his best, he had taken a big risk, and he had saved the life of the patient. And actually, we found from the record when they came to me, I have a habit, and that's extremely important, even for you doctors to, do that. When you go to a legal practitioner, there's a case filed against you, you should know your record backwards. You must know every page in the file. How we discovered was that this man was actually addicted, and he had been the doctor, the patient. He was addicted, and he was continuously injecting himself and taking the drugs, and his entire arms were punctured. The doctor who was treating him had taken a picture and had done a videograph of it. So when he filed the complaint, he didn't disclose this. We produced this before the National Consumer Disputes Redressal Commission, and we were able to, bring the doctor who had been sued out of this case because there was negligence on the part of the patient in not disclosing the entire facts of the case. And they very often, what they do is, if you are attached to a huge hospital, you're a successful doctor, you become more vulnerable. And sometimes people who sue you are from the same profession. So why I'm telling you all the facts in such length, and of course, while the matter was pending in National Consumer Disputes Redressal Commission, the patient unfortunately expired, but that was in the course of life and not anything to do with the treatment. Several years after that had happened. So I do want to tell you all some real life examples because I have dealt with various hospitals and doctors during my practice. Now, India has followed broadly the jurisprudence which was, set in England. And the first test was the Bolam test. I'll just tell you what the Bolam test was and we'll move on because today it has really become obsolete and the courts have moved on even in England. The Bolam test was that if the doctor exercises ordinary skill of an ordinary competent man, exercising that particular art, he is not guilty of negligence, but it is of an ordinary person. Thereafter came the Bolitho test, and in the Bolitho test, the court said you can't use such low standards. The threshold has to be higher. And then they said the court has to be satisfied that the exponents of the body of of opinion relied upon can demonstrate that such opinion has a logical basis. In particular, the weighing of risks against benefits. The judge, before accepting a body of opinion as being responsible, reasonable, or respectable, will need to be satisfied that in forming their views, the experts have directed their mind to the question of comparative risk and benefits and have reached a defensible conclusion. So, Bolitho test raised the threshold of negligence. And today what is in force is the Montgomery test, which was by a 7-judge decision passed by the UK Supreme Court. And I'll just read out the bullet points to you and no more. The doctor's duty in providing information while taking consent from a patient is not to be judged by reference to the Bolam test. He is under a duty to take reasonable care to ensure that the patient is aware of the material risks involved in any recommended treatment and of any reasonable alternative or variant treatment in the same branch of medicine. So that is what you are required to do in law, that you must disclose material risks, not every small minor risk. I mean, then you'll scare the patient will run away. That's not the object. Object is that if it's a major issue, you must tell them that these are the other alternatives and why he's recommending the one which he is going to employ. So basically, it involves more communication with patients. The entire approach is more patient-centric now. The only therapeutic exception is a doctor can withhold information from the patient about a risk if he reasonably considers that its disclosure would do serious harm and detrimental to the patient's health. So it's in a very marginal case where you will withhold information, not otherwise. I want to now dwell upon consent because there is a lot of jurisprudence on this, and this is mostly from the Indian Supreme Court. So I will dwell on it for a little while because this is extremely important. I've done several cases where people, after having given consent, have denied it, saying it was taken hurriedly, it was taken while they were being wheeled into the operation theatre, it was taken later. So this is very crucial, and this is of utmost importance in safeguarding the interest of doctors because it's contemporaneous record of what was disclosed to the patient. Because what you tell them orally, there is no proof of it. It is only through the written consent, whether the doctor has disclosed to you what are the treatments. It should be done meticulously and carefully by a doctor from the treating team and not some nurse or some junior doctor from some other department. That is why I do want to spend at least 5 or 6 slides on this issue. The landmark judgment in the Supreme Court of the Supreme Court is Dr. Samira Kohli. I'll come to that in a few minutes. The basis of consent is that a patient's right to bodily integrity and self-determination is the basis of consent. That is, a patient is entitled to know what is the treatment he's being provided so that he can decide whether he wants to take it or not. So it emanates from the right to life under Article 21 of the Constitution of bodily integrity and self-determination. That is what it's based out of. Now, informed prior written consent is mandatory for major diagnostic, anesthetic, and surgical procedures. For all major procedures, you must ensure that prior written consent is taken and not later, and not while the patient is being wheeled into the operation theatre. The doctor from the treating team must explain to the patient the prognosis, the problem, and what is the treatment being taken, and if there's any other alternative. Consent form is a medico-legal document. If a patient is conscious, oriented, he must give the written consent himself. If he is unable to sign for any reason, you can even record his oral consent on a cell phone and have it countersigned by next of kin who's available there so that you are safeguarded. And it should be countersigned by the medical practitioner with respect to the advice which has been given to the patient. Informed consent is that you inform the patient of the prognosis and the course of treatment advised. Consent, now this is very important. Consent given for a specific treatment procedure will not be valid for any other treatment or procedure. The famous cases of Dr. Samira Kohli versus Dr. Prabha Manchanda, she was a 44-year-old lady, and so she was having a problem with her menstrual cycle. So the doctor said, you need to go through a sonography. While the sonography was going on, the doctor walked out and spoke to the mother and said, I think we need to do a hysterectomy, we need to remove the ovaries and the fallopian tubes in addition. Mother gave the consent on the basis of the advice of the doctor, and the doctor went ahead and carried out this entire surgery. So when she came to consciousness, she was very offended by it, and she filed a medical negligence case against the doctor, which was allowed in her favor. They said that if there was a possibility of you doing it, you ought to have taken it from the patient. She said, it's affected me permanently because I can never have a child, I can never get married. Even though she was 44 years old, it's all right. I mean, you don't foreclose anyone's options like that. It was not an emergency. It was not an emergency. So the Supreme Court held that if you have taken consent for a particular procedure, it is relevant only to that procedure and not otherwise. And the only exception to this is that if the patient is in a life and death state, then you can, it will be an exception and you can go ahead and carry out the procedure and not otherwise. Now, the information which is to be disclosed, what is valid consent? Valid consent is that the nature of treatment must be disclosed, the risks and benefits, known side effects, available alternatives, and highlight comorbidities and allergies, if any. The consent form is considered as a proof of communication and counseling done to the patient and his relatives. There is no need to explain remote or theoretical possibilities. Written prior consent must always be taken on blank forms by a doctor from the treating team and none other, not a nurse, not some junior doctor in some other department. In high-risk consent cases, if the patient is in a critical state or a high-risk patient, the treatment, or if the treatment entails removal of any body limb, the rate of failure is high, relapse is common, presence of comorbidities, treatment expected to take a long time, these are high-risk cases. In these life-threatening situations, it is necessary that the prognosis, the high-risk consent are specifically disclosed and recorded in the consent form. Form must be preferably signed by the patient. If the patient is not in a position to give a written consent, oral consent may be recorded contemporaneously on the treatment sheet, and also you can take it orally. People record all the time on the cell phones. You must have some backup. And written consent must be taken of the next of kin, close relative, and countersigned by a doctor from a treating team. And the therapeutic exception is the requirement of written consent. It's prior written consent, not post. Prior written consent may be dispensed only if the additional procedure can brook no delay, since it is necessary to save the life or preserve the health of the patient. Now, persons who are not competent to consent, what do you do? For instance, in the case of a child, a minor, or a person of unsound mind, or even an adult who may be of sound mind, not in a position to articulate, then only do you go to the next of kin, and it should be duly witnessed by another relative to safeguard yourselves. Now, minor proxy consents, child below 12 years, the child's consent is irrelevant. It is the parents or the guardian who must give consent. There was this child whose case came before me while I was doing cases for one of the leading hospitals in Delhi, where there was one adult guardian with the child and no one else from the family. So the doctors informed the guardian. They turned around later on and filed a case of medical negligence, saying, why did you not take off the parent? He said, because they were not available. I took it off the person who was available. And it became a major issue, and then we got it settled out, saying that what does a doctor do if, the child comes with some other adult, the parents are not there, what do we do? So if the time permits, insist on only a parent coming, not anyone else. If parents not available, then a guardian. So you have to take care of your own interest when you deal with these kind of cases. Between 12 to 18 years, you can take consent of the patient as also of the parent. It's not either, it's both. Consent of, suppose the parents are having a discordial relationship, then consent of any parent or the caregiver would be valid. In the case of a child who has got hurt or is in an emergency in school, the teacher or warden who brings a child into emergency, their consent can be taken. And consent in emergency is an act done in good faith, not culpable. I will now take you all directly to the remedies for medical negligence. I just want to familiarize yourself, no more. One is complaint for deficiency of service before the consumer commissions. for breach of duty of care and compensation. This is the first. This is where people ask for damages. The second is disciplinary proceedings against a medical practitioner, which is before the State Medical Council. And the third is a case of criminal negligence where a complaint is filed under section 200 CRPC for an offense under 304A for rash and negligent act. Under the new act, there are 3 tier. The district commission where the claim doesn't exceed 50 lakhs. State consumer where the claim is up to 2 crores. National commission where it exceeds 2 crores. This is broadly how the pecuniary jurisdiction is of the commissions. The period of limitation is 2 years. There is no cap, this is important, on the amount which can be claimed in a medical negligence case in India. Therefore, it's very important for all medical practitioners to obtain professional indemnity insurance, and particularly in hospitals, the policies cover only full-time employees and not part-time consultants. So you must be aware of it. It is, I think, it has become imperative to get professional indemnity insurance, and you must be mindful of it. Today, under the new act, this is an issue which bothers me when it comes to hospitals and doctors. The jurisdiction has become too wide. A complaint can be instituted in a district commission within the local limits of whose jurisdiction. One is the hospital or doctor reside or carry on, that's no problem. B is any of the opposite parties, where there are more than one, are situated. And third is cause of action, wholly or in part arises. And fourth is where the complainant resides or personally works for gain. Now, my problem with this is, in the earlier act, it was not where the complainant resides or personally works for gain. Suppose someone lives in Hyderabad, they come for a treatment to Delhi, and they feel that there has been medical negligence by the hospital or doctor, they can file it in Hyderabad also. Now, for a medico to keep leaving his practice and running around is very hard. It should be, in my view, that it should be where the treatment was given, because that was what we had got that interpretation from the courts, that you can't, suppose someone lives in Andaman and comes to Tamil Nadu, how do you expect the doctor, the hospital, they'll all be affected? And believe me, from my experience, most of these cases we found are speculative in nature. They are done at the behest of other doctors and hospitals. So I think protection is required. And I do believe that the doctors need to make representations for a proper act to govern medical negligence and not the Consumer Act. The service which a medico provides, medical service, cannot be equated with a consumer service. It has to be done. I have been telling doctors all over the country, wherever I have gone and addressed conferences, please take this into hand. The jurisdiction has to be confined. The tribunals must be specialized. The tribunals should be manned by people who are familiar with medical negligence. And while I was a practicing lawyer, I used to ensure that the doctor was made himself available. I would give him the dates when I would address the court finally to get his input. I am not a doctor, I am a lawyer. I can read the file, but I need the input from the medical man to guide me as to what will be the answer, because neither are the judges medical people, except in the National Consumer Disputes Redressal Commission, we have Dr. Kantikar, who's a very, very competent and a fair doctor who's been there for many years. And he's been fair, whether it's a hospital or, a patient who's making the complaint, he's even-handed, and that's what you want. You want a fair adjudication. I think we need a specialized tribunal, and you all must make a representation to the government to come out with a centralized act. Because today there is a lot of problem. The jurisdiction has been enlarged by the 2020 Act, and I'm very displeased seeing this because it can cause a lot of harassment. Then services which are outside the purview of the Consumer Protection Act are when it is provided basically free of cost, like government hospitals are not covered by it, or where it's provided free of charge. The onus in a medical negligence case is always on the complainant to prove the allegations. The only exception is in the case of res ipsa locutor, where the act speaks for itself. And I have given you all one instance. It was the case which is a reported case of Jaswinder Singh versus Santok Nursing Home, a case where 2 mops gauzes were left in the abdominal activity, led to septicemia and death of the patient. So there the onus is on the hospital and the doctor and not on the patient. Disciplinary proceedings, I won't go into it, but I mentioned about it. It's under the National Medical Commission Act 2019, read with the regulations. I want to also impress upon you all with respect to the IMC regulations, which still continue to remain in force. Maintenance of medical records is of primary importance because it's a contemporaneous record which helps us in fighting a medical negligence case. The regulations provide that you must maintain the record for 3 years from commencement of treatment. And today, with the advancement of technology, you can do it through electronic form. The second most important point is that medical records, every doctor is under a statutory obligation to provide it, latest within 72 hours, if a request is made by the patient or authorized representative. In the case of Maharaja Agrasen Hospital, the Supreme Court directed that since there was a delay of, I think, over 3 years, there were costs imposed on both the hospital and the doctors for withholding the record because the record was also found to have serious interpolations after the case had started. So this would amount to misconduct, and so therefore, very often doctors say, why should we provide the medical record? You are obligated by law to do it. Criminal negligence, what is the difference between civil and criminal? Criminal negligence is where the standard is much higher. It is a case where there is criminal intention. Mens rea means criminal intention. It is a necessary ingredient for criminal negligence. The standard of negligence in a criminal complaint is gross negligence or recklessness by the doctor in giving treatment, irrespective of what would be the consequence. And the leading judgment, which I would advise you all to see, is Suresh Gupta versus Government of NCT Delhi and Malay Kumar Ganguly, where a huge compensation was awarded by the National Commission and the Supreme Court, running into some crores. Now, insofar as criminal complaint is concerned, for the protection of doctors, the judgment of Jacob Matthew came in, where they said every other person goes and files a private complaint anywhere. What do you do? So the court said in Jacob Matthew that when a private complaint is made of medical negligence, it must be accompanied by a credible opinion of a doctor in the same branch of medicine. Suppose it's a cardiology issue, it should be by a cardiologist. And things. One is what I found through my experience, particularly while I was practicing as a lawyer, is that proper documentation and maintenance of records is of prime importance. At the time of admission, please obtain past medical records of the patient, even if it is in electronic form, with respect to the treatment taken in the past, duration of illness, and comorbidities. I found in some cases that patients had orally told the doctor that they had gone through this treatment. Subsequently, when they file a criminal negligence case, they don't produce the record. Now, you can't really base it on an oral communication which happened some years ago. It's important that the doctors retain the past record, maybe in electronic form, because sometimes people don't want to part with physical copies. You can always, it is very, very helpful in fighting a medical negligence case. Then second is when the patient comes into your hospital, there has to be proper maintenance of records, which is crucial since it is contemporaneous record of what was advised and what was the procedure provided. I found in some cases that there was discrepancy between the doctor's prescription the nurse's chart, and the discharge summary. So please don't take these things casually, because that's what helps when a medical negligence case is filed. And sometimes you never know, in the most innocent of cases where you've given good treatment and the patient has survived, a medical negligence case is done for probably speculative reasons. Then discharge summaries must always be filled up by a doctor from the treating team and must tally with the medical records of the patient. In death cases, the cause of death must be carefully filled up in the death summary, and a senior doctor from the treating team must speak to the family of the deceased. If a person has donated his eyes, organ, or any part of the body for therapeutic or any other purpose, after his death, the same should be removed only after obtaining written consent of the spouse, natural guardian, next of kin. And the last point which I just wanted to touch upon was with respect to the increasing violence witnessed, particularly during the Delta wave of COVID-19, on the medical doctors. And for that, since health is a state subject, it has to be dealt with at the state level, and you all must ensure that you have a good act in place in your state so that you are protected from this kind of violence. These are broadly my thoughts, and I'm happy to share them with you. And if anyone has any question, I would be happy to answer them. Thank you.
Questions are welcome, sir. Please introduce.
Really amazed to hear you, madam. I have not heard this much clear view from anybody in past. I have one question, madam. Madam, this new Consumer Protection Act 2009, this old is repealed. This is new act. And when we learned in our LLB that there was a subject of interpretation of statute. So whenever we are interpreting a law, we always go to the discussion which was held in Rajya Sabha and Lok Sabha. And in both manuscript, it is available on table or on record that the minister Paswan sir was there, and he categorically mentioned in Rajya Sabha and Lok Sabha that I am removing this medical people out of CPA. So why this interpretation is not been accepted by the courts? You have mentioned we filed a case, a medical legal action group filed a case in Maharashtra, and we paid 50,000 rupees fine for the same. So we are trying to go to Supreme Court, but it is pending over there, multiple litigation. So I want your opinion, madam, that for interpretation, whether this Rajya Sabha and Lok Sabha manuscripts should be taken into consideration or not.
It's not that. In my view, if the court had said that you all are not covered, there would have been a vacuum in the law. There would be no other place. So they continued the same procedure. The way forward is that you should go to the law minister and you should take a huge number of doctors' associations and tell them that you all must get a separate act for medicos. You can't be treated as a consumer service.
Thank you, ma'am. I'm a specialist in ultrasound. I have a peculiar problem. A patient is referred to us, and with the doctor's letter says 19 years old. And yeah, patient is referred to us for an antenatal scan and referred as 19 years old. Go and check the records. Actually only 60 years. Now, am I responsible to go notify it? Because if it's a child getting pregnant, I'm supposed to notify the police. So, am I responsible for it, or the referring doctor who is responsible for it? I'm doing a service for the referring doctor.
Actually, in this case, the referral doctor really won't be in the picture. this is a falsehood by the patient who comes to you. So if you feel that they are in the cusp 17, 18, 19, you should ask for proof. Take it from the patient. The referral doctor really won't have any role to.
Okay, thank you.
Ma'am,
if it is a POXO case, you will have to immediately refer to you will have to inform the referral doctor and also inform the authorities that a girl has been affected. If it's a minor and she has been raped or subjected to sexual abuse, and you come across, as a professional, you are entitled to inform the authorities immediately. You are bound to inform to your referral doctor saying that the information given by the patient is wrong, and as per our diagnosis, she is less than 16, she is less than 18 years or whatever it is, you will have to immediately inform, or you will have to face the consequences.
ma'am, so many things which are from since yesterday morning we have been listening, and so many things we seem to be following the Western country standards, even the Bolem's test and the other test, all those things. But unfortunately, we have a different type of, our culture is different, the way we have been brought up is different. So what happened, I am an orthopedic surgeon. I operate on people of 80 years, 85 years for hip fractures. So the consent says, as per the consent, I am supposed to tell them all the complications so the patient is able to understand. The 85 years when I operate on the hip, there is a possibility that the patient may die on the table at that age. So if I go and tell the patient in the bed that for you to walk, I have to operate on you, but there is a possibility you may die on the table. But in our nation, is it possible to say like that, and can we expect the patient to give the consent? And the teaching, medical teaching says, and everybody says, that we have to keep the patient very comfortable. And also, when the patient is going for a surgery, we can't put the patient under tension. So, how is it possible for us to go and tell that you may die on the table? That is one problem. So, what we do nowadays, I personally take the risk of not telling it. I am prepared to go to the court and face the consequences if at all something happens. I only tell the close relatives, get their consent, make them understand, because morally, my conscience says that is the better way of doing it, even though legally it is not right. So please help us in those situations, how to go about. Because all these things which you have been hearing, some of them seem to be too theoretical things, which unfortunately we are not able to follow in practice, because we are dealing with human beings who are brought up in our culture. We are not to, I hope you understand my
response to you is, you can certainly, if you tell the patient that he may not, get up from the OT, he'll surely run away. But you can certainly tell the spouse, the next of kin, that it's a very high risk case and fatalities are high. So you can put it in a more, you have to be careful as to how you communicate it. Because, very often what happens is sometimes a patient says, I don't want to go through it. So, a surgery. So I think that information has to be disclosed, whether directly or indirectly. Like I know a patient who's recently, she was discovered that she had a hole in her heart. It was congenital, but it's come to light only when she's about 74, 75. She said, I don't want any treatment. I'll pass when I have to. I don't want any treatment. So I think that fatality is very important, which has to be conveyed at least to the family. Then next, you can't put it so starkly to the patient, but you can say it's a very high risk case, and the fatality word is a little worrisome when you tell a patient, but I think it has to be conveyed to the family at least.
But the law says in a different form. In a court of law, only what is there in the records speaks.
No, so what you are orally communicating, you can say high risk consent is obtained after disclosing the, the various risks involved, including, high degree of risk you have to word it carefully, but I think that has to be disclosed. Very often, today I know a lot of patients who get cancer, they say, we don't want to undergo chemo. So, and sometimes doctors also push too hard. You know, because after all, it is revenue generating, you have to make a balance. They have to be told, they have to be disclosed. They say it is my right of autonomy and bodily integrity and self-determination as to what is the treatment which I'll be given and what is the correct prognosis.
Okay, thank you, madam.
Madam, your speech was very useful for all of us. One of the slide you said services that does not come under CPA.
Sorry, that?
Services that does not come under CPA. Free service.
Yes.
One of which you said government hospitals.
All government hospitals are exempt from CPA.
Yeah, but some of the patient we charge, like some paying patients are there. But
That's okay, that's all right. There
that
was a
doesn't
case
change the
which was-
position of the
couple
government
of
hospital.
cases were filed against Safdarjung Hospital. I was dealing with those also because it's a free hospital in Delhi and a premier hospital. That was not held to come under medical negligence.
So even if
Because
some of the patients were charged,
some of the treatments are charged, you see, and then there is a registration fee, token registration fee and all won't bring it under CPA. These are reported cases.
thank you, madam.
Madam, I work in a small town. It's a small hospital. So patient initially says, patient is very sick, he has got a myocardial infarction. So we all know once the patient develops myocardial infarction, he can develop cerebral thrombosis, he can die. So he was initially admitted, patient says, you save our father, whatever thing you do, we'll spend all the expenses. But we don't have all the specialists all the time, always. Cardiologist, only one cardiologist in our town, he was not available, he was out of station and the patient got admitted. And neurologist, neurophysician was also not available. So initial physician, he admitted, he looked after the patient, his cardiac condition was stable. But later after 2 days, he developed cerebral thrombosis, he died. Now the patient attender claims that cardiologist didn't see the patient, neurologist didn't see the patient, it was negligence, so you killed my father. Is it how to go about it?
You will have to disclose that it can lead to thrombosis and to take the patient to a bigger hospital. If you know there's just one person, you have to advise him, then take him to a bigger hospital because we don't have, someone around the clock here. That has to be done.
Yes, ma'am. We have already told him. This cardiologist is not there. He gets admitted in ICU. He's very sick. He's not.
So then what you do is to safeguard yourself. You say it was an emergency. We provided the treatment. We've informed him. It's a small place. There's nobody else available. Because time taken to transport him may have also caused his death. You will have to safeguard yourself.
Yes, ma'am. Once we referring, our town is 160 kilometers from Chennai. So every patient you start referring all the patients, then we cannot treat any patient in the smaller towns.
That is a problem. That is a problem. There isn't sufficient medical facility in the smaller places and villages.
We can...
Sir, I think we can discuss this with our councils.
Yes.
Please.
Thank you.
Yes. Thank you, sir, for your understanding. Now honoring the guests. Madam, it was a wonderful talk, and I think we can give her a round of standing ovation, please, for the excellent narration of what is a must and what is not a must. Thank you so much. Now honoring the guests by the office bearers of the state office. Madam will be honored by our state president. In the presence of the organizing committee chairman and secretary. I request the current office bearers also to join the honoring. Just a minute, wait, photographer, please wait. Let them go. I request the well to stay back, and honoring State Secretary will honor Justice Jagdish Chandra, sir. Now, I request our guests to honor our past office bearers. Madam and Sir, to honor our past office bearers. President, sir? Yes. I request Dr. Captain Raghavel, sir, to go and receive his recognition. Founder, trustee of PPLSS. Today, all these things are happening because of the great efforts of people like him. Please give him a good ovation. Next will be Dr. Balasubramaniam, sir, Founder, Secretary and PPLS Chairman 2010-13. Bala, sir. Bala, sir. Next will be Dr. Gunasegaran of Tiruchirappalli. Turning up in PPLSS Secretary 2004-7, PPLSS Chairman 2013-15. That is Dr. Gunasegaran, sir, for you. Next, I request Dr. K. Tangamuthu, sir, PPLSS Secretary 2013-15, Chairman 2019-21, to be ready to receive the awards. Tangamuthu, sir, award for Tangamuthu. Next will be Dr. Prakasam, sir, from Salem, PPLSS Chairman 2017-19. Please appreciate our past office bearers for the excellent service they have rendered PPLSS at IMA. They need our good round of applause. நல்லா கை தட்டினீங்கன்னா நல்லா பசிக்கும். Please. Now I request our State President, sir, who served as PPLSS Secretary 2015-17, to receive the award.
Dr. Palnisamy, sir, Coimbatore immediate past president, IMA TNSB.
Former PPLSS Treasurer, sir.
Dr. Abul Hasan Yiro. Right. Dr. NRTR Tyagarajan, Secretary, IMA TNSB. Sir. Dr. Chandrasekharan Panruti, PPLSS Chairman 2021 to 2023. One Alberer. Dr. Manivannan, Salem, PPLSS Secretary 21 to 23.
Dr. Chandrasekhar sir and Dr. Manivannan have worked hard to make this Silver Jubilee celebrations a grand success.
Dr. Ilangovan Tanjavur, PPLSS Chairman 23 to 25.
Now, Dr. Lenin sir. The following also receive a special token of appreciation from the organizing committee of the Silver Jubilee. Dr. J. Jayalal, past National President, Secretary General, Commonwealth Medical Association. Dr. Edwin Joe, sir. Former Director of Medical Education, Tamil Nadu Government, and Professor of Forensic Medicine, sir. Currently Dean of Tiruchengodu Vivekananda Medical College. Always in the academic services. Dr. Payani, sir, consultant neurologist. Dr. Payani. Dr. Swaminathan. Karthik. Dr. Swaminathan. Last but not the least, the backbone of our PPLS organization, Mr. Anand David, our learned counsel for PPLSS, helping so many doctors all through and working hard and helping us in this conference. Thank you so much, sir. Balaganesh irukka? Balaganesh. 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 Ille. Dr. Balaganesh will be here. Thank you. We thank the dignitaries for showing patience in appreciating and awarding our former office bearers who has made this scheme a success story of Tamil Nadu Indian Medical Association, madam and sir. They have been rendering great service to our medical fraternity. And sir, RMK sir, the man who was in charge of Quackery Eradication Committee for more than 5 years and our honorable former state president, octogenarian, still very enthusiastically attending all the meetings and conferences. Thank you, sir, for being with us. All through it had been a wonderful morning session, sir. With the permission of the state president and organizing committee, will be adjourning for lunch. And the post-lunch session will start sharp 2:30 because the speaker has to leave by flight. I request all your extreme cooperation in coming back to the hall by 2:30 to listen to his talk. And your speaker will be none other than our oratorial king, Dr. J. Jayalal, past national president. So don't miss the topic coming soon after your lunch. Please.